Judgment in the matter of N3 against Secretary of State for the Home Department and ZA against Secretary of State for the Home Department.
Lord Sales will explain the court's judgment. This case is about the legal regime under which a person who has become a British citizen can have their citizenship removed in certain circumstances. That regime is contained in the British Nationality Act 1981, which has been amended from time to time. If someone is a British citizen, then by virtue of that status, they have a right to enter and reside in the UK. Children born to them may also acquire British citizenship. A decision to deprive someone of citizenship is taken by the Secretary of State, but then may be tested in proceedings in a tribunal. The relevant tribunal in this case was the Special Immigration Appeals Commission, which deals with immigration matters which involve questions of national security. The Commission was the relevant tribunal because the Secretary of State made deprivation orders in relation to two individuals designated as E3 and N3 because she suspected them of being involved in Islamist terrorist organisations and assessed that they were a threat to national security. On that basis, the Secretary of State considered that it was in the public interest that they be deprived of their British citizenship. If E3 and N3 were deprived of their citizenship, it would mean that they could be detained and expelled from the UK if they were present here, and they could be refused entry here if trying to come from abroad. The 1981 Act contains an important limitation on the power to deprive someone of their citizenship, even if there are otherwise good reasons to do so. That limitation is that a person cannot be made stateless. This reflects an obligation on the UK in international law under the Statelessness Convention. The Secretary of State made deprivation decisions in the cases of E3 and N3 in 2017, believing that they had dual British-Bangladeshi citizenship. Therefore, the decision to deprive them of British citizenship would not make them stateless. They would continue as citizens of Bangladesh. The question whether someone would be made stateless by a decision to deprive them of their British citizenship may involve difficult issues of foreign citizenship law. A difficult evaluative assessment may have to be made whether they would or would not continue to be citizens of that foreign country. That was the situation in the case of E3 and N3, and also in the case of certain other individuals whom the Secretary of State believed to be dual nationals of the UK and Bangladesh, and whom she decided to deprive of their British citizenship for similar reasons. This appeal is about what happens if the Secretary of State concludes that a person would continue to be a citizen of a foreign country if deprived of their British citizenship, and so decides that it is lawful to make a deprivation order, but the person appeals against that decision, and on closer examination with additional evidence, the relevant tribunal allows the appeal because it concludes that the person is not, in fact, a citizen of that country. Accordingly, the tribunal decides that the deprivation order would render them stateless and is unlawful. Under Section 40, subsection 4 of the 1981 Act, the Secretary of State may not make a deprivation order if she is satisfied that the order would make a person stateless. This rule is formulated in subjective terms. It depends on what the Secretary of State understands to be the case. However, if the person concerned appeals to the tribunal receives additional evidence and it makes up its own mind whether the decision would make the person stateless or not. Once the tribunal makes its decision, that is binding on the parties. In other words, if the tribunal decides that the person would in fact be made stateless by the Secretary of State's order, that is determinative. The Secretary of State is bound by the tribunal's decision, even though at the earlier stage she may have had a reasonable basis for thinking the opposite was true. As the deprivation regime was originally structured, once the Secretary of State had taken a decision to deprive someone of British citizenship, that person could appeal that decision to the relevant tribunal, and while that appeal was outstanding and had not been determined, the Secretary of State's decision was suspended in its effect. In other words, while the appeal was ongoing, the Secretary of State had to continue to treat the person as if they continued to be a British citizen. This had significant implications. Pending a decision by the tribunal, the Secretary of State could not take steps to subject the person to measures to remove them from the UK, nor could she prevent them from entering the UK. And this was so even though she suspected them of involvement in terrorism and assessed them to be a threat to national security. To address this issue, the 1981 Act was amended so that, at least for certain purposes, a deprivation order made by the Secretary of State would have immediate effect. The consequence of this was that in the interim period between the Secretary of State's deprivation decision and the determination of an individual's appeal by the Tribunal, the deprivation order she made would be carried into effect. The individual could be detained and removed from the UK or could be refused entry here. In this way, national security would be protected. However, what would be the position if the individual's appeal to the Tribunal was successful later? From the date of the Tribunal's decision, it would be clear that going forward, the Secretary of State would be bound to treat the individual as a British citizen. But what about their status in the interim period between the Secretary of State's deprivation decision, which was, on the face of it, lawful, according to the subjective test laid down in Section 40, subsection 4, and the Tribunal's decision allowing the individual's appeal against that decision? In this appeal, the relevant dates are 2017, when the Secretary of State made her deprivation decisions in relation to E3 and N3, and April 2021, when an event occurred which was equivalent to the relevant tribunal allowing their appeals on the grounds that deprivation of their British citizenship would make them stateless. That event was not an actual determination by the Special Immigration Appeals Commission of the appeals brought by E3 and N3, but a concession by the Secretary of State that those appeals must be allowed. That concession was made because another decision by the Commission in 2021, in cases involving supposed dual nationals of the UK and Bangladesh in the same class as E3 and N3, had determined that in fact the individuals concerned did not have Bangladeshi citizenship. It was found that individuals in that class had lost their Bangladeshi citizenship sometime previously when they turned 21. Therefore, deprivation orders in such cases would make the individual stateless and would for that reason be unlawful. An added complication in the present appeal is that in June 2019, that is, in the interim period, E3's daughter, designated ZA, was born in Bangladesh. If E3 was a British citizen at the time of her birth, the law contained in the 1981 Act means that ZA would have British citizenship by descent. So the question whether E3 should be treated as qualifying as a British citizen in the interim period has a big impact on ZA. A dispute arose about the citizenship status of E3 and N3 in the interim period and about whether ZA is a British citizen. The Secretary of State maintained that E3 and N3 had been validly stripped of their British citizenship in the interim period for all purposes. She also maintained that as a result, ZA is not a British citizen because E3 was not a British citizen at the time of her birth. E3, N3 and ZA sought judicial review, claiming declarations that E3 and N3 were to be treated as British citizens in the interim period for all purposes, and that ZA is a British citizen. Their claims were dismissed by the High Court, and their appeals were dismissed by the Court of Appeal. N3 and ZA now appeal to the Supreme Court. The Supreme Court unanimously allows ZA's appeal in full and N3's appeal in part. The court holds that if a deprivation order is withdrawn, it is to be treated as having no effect for the purpose of determining an individual's citizenship status in the period from the date of the making of the order until it is withdrawn. E3 and N3 are therefore to be regarded as having British citizenship throughout this period. The consequence of this for ZA is that she is a British citizen by virtue of E3's status as a British citizen at the time of her birth. This conclusion represents a middle position between the submissions of the appellants and the submissions of the Secretary of State. The court rejects the first ground of appeal put forward by N3 and ZA, that the power of the Secretary of State to make a deprivation decision, as set out in Section 40, subsection 4 of the 1981 Act, arises only if an objective precedent fact is true, namely that deprivation of British citizenship would not render the person stateless. To the contrary, the court concludes that the wording of Section 40, subsection 4 makes it entirely clear that a deprivation order can be made by the Secretary of State on the basis of her own subjective assessment of the position, having regard to the evidence available to her at the time she takes the decision. This means that in the interim period between the making of the deprivation order by the Secretary of State and the conclusion of the relevant tribunal on the appeal, the deprivation order is to be treated as valid and effective for at least some purposes. That is so even though the appeal is later allowed on the basis of different evidence by the tribunal. The significance of this is that in the interim period, the Secretary of State is entitled to detain and remove the individual from the UK and to prevent them from entering the UK. The appellant's suggestion to the contrary is wrong. However, the court allows the appeals on a more nuanced basis. It rejects the countervailing argument of the Secretary of State that because deprivation orders she made were valid for those purposes in the interim period, they have to be treated as valid for all purposes in that period, even though that would mean that N3 and E3 were rendered stateless during that period. In the court's view, important presumptions apply in interpreting the operation of the current regime under the 1981 Act in relation to the effect of a deprivation order in the interim period, in circumstances where a binding tribunal decision is later made that the true effect of that order, if treated as valid, is to make the individual stateless for a period. There is a presumption against the person being deprived of such an important right as British citizenship, where there is no good reason for that, especially where a tribunal decides that point. There is also a presumption that Parliament intends to legislate so as to comply with the UK's obligations under international treaties. Clear statutory wording is required to displace these presumptions. In the 1981 Act, there is clear wording that the Secretary of State can lawfully make a deprivation order at the outset on the basis of her subjective assessment regarding statelessness. However, it is also clear that she is bound by a later decision to the contrary by the relevant tribunal. Under the amended scheme of the 1981 Act, the purpose of giving the Secretary of State the power to make a deprivation order so as to allow her to act on the basis of it is to enable her to take effective immigration control measures. But it is only to that extent that it is clear that the legislation displaces the usual presumptions I have mentioned. Therefore, when one moves away from the area of implementation of immigration control measures to look at other aspects of deprivation of citizenship, the usual presumptions continue to govern in determining the true meaning and effect of the 1981 Act. The consequence is that, looking only at the citizenship status of E3 and N3 in the interim period, without any question of the validity of immigration control measures taken against them in that period being in issue, E3 and N3 continued for all other purposes to be British citizens throughout that period. They cannot be treated as having been made stateless in the interim period, as would occur if the deprivation orders made by the Secretary of State were to be treated as valid for all purposes in that period. The major effect of this analysis, in ZA's case, is that E3 was a British citizen at the time of her birth, and that means that ZA acquired British citizenship at birth.